Are you ready?
Yeah.
You sure?
Yeah.
You sure about that?
Yeah.
All right. Hello and welcome to Learning the Law, a podcast about all things legal with a focus on current events where we try to teach you things in an hour. My name is Ashley, aka Phoenix Nymphy. My co-host, who is the man of the hour, my husband, Ron.
Hello.
This podcast is purely educational and should not be taken as legal advice. This podcast does not create an attorney-client relationship. This podcast is based on his interpretation of relevant law, and any opinions expressed are the opinions of the individuals making them and do not reflect the opinions of any firm, company, or other individuals. Ron is a licensed practicing attorney in the state of California.
Yes, I am. Since 1999. September.
This week, I've done this before. I've totally done this before. I know what I'm doing. This week, the podcast is sponsored by NordVPN. With more than 10 years of experience, NordVPN is a leading VPN provider. NordVPN gives you military-grade protection online, and you can access all your favorite sites without restriction. NordVPN never logs your activity when using their servers. You can always trust your privacy to NordVPN. Thank you for sponsoring the podcast. If you use our link, you can have access to all this and also help out the podcast. So definitely check out the link below. And in the chat. And yeah, so part 2 of our deep dive into Roe v. Wade is what's happening.
Yes,
So we were not here last week because I had surgery last Monday. It went very well. Everything went well. They did the stuff and the things and all the stuff, and recovery's going quite well. So I don't really have anything else to say other than that. What about you?
I'm glad everything went well. You know, what else can I say? I didn't do any physical therapy last week.
Or this week. Did you call, by the way, and ask and set up a thing for that?
I can only email my primary care physician.
Okay. You should be able to call and make an appointment.
Yeah, I'm going to have to do that tomorrow.
So, yeah. Update on the SCOTUS stuff. I think we mentioned in the last podcast, they pushed it forward. So they're going to actually listen to the Texas abortion law before they listen to the Mississippi abortion ban.
Yeah, they already have listened to the arguments last week.
Yes, on Monday.
On the first, yeah.
So that's it. All they've done is listen to the arguments. They've done nothing else. I don't think they've come out and said anything officially yet.
No, but observers that monitor how the questioning was going think that they will not let the Texas law stand.
What I've been reading is that it's based on the technicalities on how it's written. And it is nothing to do with the fact of the content. It is how it was written and the fact that it is deliberately avoiding the proper due diligence of the system. And they're more frustrated with that about the law than anything else, which...
But, right. Every entity likes their own power.
Yeah.
And the law takes away from the Supreme Court's power as written. Therefore, the Supreme Court is pissed off.
Well, it also takes away the power of police force too. Like the whole justice system, it just laughs in the face of the entire justice system from the police force on up. And I mean, we all know my opinions on the police force. It needs to be overhauled anyway, and needs to have a different, because that whole thing is rooted in racism. But that's a whole different podcast.
Yeah, as is, where does the Supreme Court get its power?
Yeah. So it's looking good, but on the other side, because we're here to keep it real. That just means that if they do say, no, we're not letting this happen based off of how it's worded, that means that there is a possibility that other abortion laws could go through just worded differently. So like it's still a fight. It's still a fight.
Well, and in a month, they hear the Mississippi case that bans it 15 weeks.
Yeah. So, and one final thing that I wanted to note before we get back into Roe v. Wade, Representative Paul Gosar from, what is it, Arizona? I think he's from Arizona.
That wouldn't surprise me. It wouldn't surprise me if he was from Texas either.
No, it's not. It's Arizona. Yeah. Okay. So if you are not aware, this week, Representative Paul Gosar put out a video, an anime style animation where they have the faces of himself, AOC, and Biden, Alexandria Ocasio-Cortez, and Biden in the video. And Gosar is literally sword fighting them and killing them in the video. And I went to go find it. And Twitter has like said, this has very graphic details, blah, blah, blah. So like, you can't just look at it. You have to like dig for it at this point because Twitter is trying to suppress it. But in my opinion, Twitter should just go, that's not cool. Get out, and ban him from the platform. But basically, it's a video and he's threatening the sitting president, the current sitting president, not just an ex-president, not just a president, but the current one, and a current sitting congressperson. If anybody else were to put some crap out there like that, and it's not just that he put the video out, it's the fact that he put the video out, laughed about it, and made jokes about it. And like, it's okay. Anybody else who would put that out there would be fired and would have the FBI and the Secret Service knocking on their front door.
And let's not forget, early in the Trump administration, Kathy Griffith had a costume for Halloween, I believe it was, where she was carrying around a machete and Donald Trump's head.
Oh, I remember that.
And the GOP got in a snicker, from that.
I mean,
this is okay. It's the same thing.
Yeah, it's the exact same thing. And so I have a hair. There we go. Got it. I had a hair that was like stuck. So a lot of people are rightfully requesting Nancy Pelosi to investigate him. Like,
well, the DOJ and the Secret Service need to investigate him as well.
Yeah.
If you or I or anyone in this audience had done that, you'd at least be getting a visit from the Secret Service.
Yeah, it's very bad taste. It's very poor taste. And it's, as much as I don't like Trump, it was wrong when Kathy Griffith did it, and it's wrong now. It's doubly wrong now because it's a sitting congressperson talking about their colleague in that manner. That's so messed up.
And he knows his constituents may actually act on that. I wouldn't be surprised if something happens to her at this point now.
Just the audacity that he said, anybody like anime? Check this out. It's not funny. It's not funny. It's inappropriate. And if anybody comes, anybody who comes and says it's just a joke, learn to take a joke. No. A joke is not funny when you are punching down on people. And that's exactly what he's doing. He is not only is he punching down on AOC because she is a person of color. She is a woman of color. A white man will never have the right to make jokes about women of color because they will always be punching down because they are the ones who have the position of power. So that's one strike on why it's not a joke. The second reason why it's not a joke is it's literally joking about killing two people who already have death threats against them. It's not funny. It's not a joke.
You want to look at it from a legal standpoint?
Yeah.
Okay. As we know, assault is not, hitting or that. It's just the threat of bodily injury. Remember that.
That's right.
So if you go to 18 U.S. Section 115, you'll find out that whoever threatens to assault, kidnap, or murder a United States official, which both of them are, a United States judge, or a federal law enforcement officer would be a crime under this section. And if it's a simple assault, which is what you would have here, term of an imprisonment for not more than 1 year, plus a fine. If the assault involved physical contact, that would be imprisonment for not more than 10 years. And if the assault resulted in bodily injury, it's a term for not more than 20 years.
Dang.
So the case could be made that this is a conspiracy to assault her.
Yep.
And do actual bodily harm. And if something happens to her, you could charge this idiot. I'm being kind with just calling them an idiot. With 20 years.
Well, it's the same. It's just the same thing as January 6th insurrection. That happened based off of several Congress people encouraging folks to do it.
Right. And don't forget, I believe it was in Minnesota. Could have been Michigan. I'm not sure. There was that conspiracy to kidnap the governor.
Ah, yes. Yeah.
And those guys are getting charged.
Yeah. So I think we are at a point where we have to hold our Congress people accountable. They should not have license to get away with this kind of concept. This kind of content. It's not appropriate. And they're literally breaking the laws. That they created. They're just laughing. Like the GOP has my mind is just, I cannot comprehend being a person who is so confident that they will have no repercussions for their behavior. And that's where the GOP is at right now. There's no consequences to their behavior. And that's why they're able to run wild with the crap that they've been doing. That's why we had an insurrection. It's why we have QAnon idiots that exist today. Like that, because there's no consequences for their actions.
Right. There's not much more to be said to that. I mean,
so let's move on to the actual topic of the podcast today. So last podcast, we went through them establishing that based off of the fact that this is a pregnancy, and by the time she went through the whole appellate process, she would no longer be pregnant, which means she does stand to reason to have this because what was it called?
compelling and evading
Yes.
circumstances, basically.
Yeah. So
Now, along with Roe, two other people had their cases merged into this Supreme Court case. And just for completeness, we'll take care of those real quick. One was a Dr. Halford. He was being charged criminally under the Texas state laws. Supreme Court said, this isn't the place. You haven't been convicted of anything yet. You don't have the standing. You haven't been damaged. We're dismissing you out of this.
Oh.
Then there was a couple referred to as the Does, who were a childless married couple that challenged the law based on possible future pregnancy. And the Supreme Court said, you don't have standing either because it's too speculative. You may never get pregnant. So they booted the Does out of the case as well.
That is one thing that kind of frustrates me about our process. There is no process for you to be preemptive on things. You have to let it happen before you can fight it. And that's kind of frustrating. And I think, and that's another reason why the Texas abortion law is such a big deal. Like you have to wait for someone to sue you in order for you to even start the legal process, right? You can't just
right.
And I understand this, but at the same time, what about the rest of the country who does have people who may need to have abortion? You know what I mean? Like, I get it. I get why they said no because of how our process works. But at the same time, it's like sometimes you need to do things preventatively. And our system doesn't allow us to do that.
No, because without being quote unquote damaged, you don't have the standing to bring a lawsuit.
Yeah. And having and not having is because they need the physicality of it, basically. They need like that because you are just kind of going based off of theory. And you're arguing theory at that point. So like on the one hand, I get it. On the other hand, it's like, yeah, but you know what I mean?
Yeah, I gotcha.
So anyway.
So that's paragraphs 21 through 32, getting rid of the doctor and the married couple.
Because they just don't qualify because they haven't quite hit
they don't have the standing.
Yeah. Yes.
To bring it to the Supreme Court. Right. The Does would have to become pregnant, not possibly pregnant, and the doctor would have to have been convicted, which he hadn't yet. So that just leaves Jane Roe, which is why it's called Roe v. Wade. So,
yeah.
When you get to 33, paragraph 33, we get into the argument and the reasoning that the Supreme Court is taking in this case. And you can see right away in 33, the principal thrust of the appellate, which is Roe, attack on the Texas statutes is that they improperly invade a right said to be possessed by the pregnant woman to choose to terminate her pregnancy. The appellant, and when I say appellant, that's Roe, would discover this right in the concept of personal liberty embodied in the 14th Amendment Due Process Clause, or in personal, marital, familial, and sexual privacy said to be protected by the Bill of Rights in such cases as Griswold v. Connecticut, 1965, which we previously talked about. And there's another one, Einstein v. Bard, 1972. Or, a third reason, the rights reserved to the people by the Ninth Amendment, which is also a holding from Griswold in 1965. And then they say, before addressing this claim, we feel it desirable briefly to survey in several aspects the history of abortion for such insight as that history may afford us, and then to examine the state's purposes and interests behind the criminal abortion laws. So I don't know that people know about the history of abortion in the U.S.
So abortion has been around since biblical times. And I'm like, we've discussed that before on this podcast, that there is, I forget which book it is, but I believe it's the book of Numbers, that tells you the concoction to have an abortion.
Yeah, it's called the Ritual of Living Waters.
Yes. Native Americans have been practicing abortion safely for a very long time. Because there are T's like that, which is where you get the basis of abortion stuff. I mean, a lot of our medical pharmaceutical stuff comes from Native American herbology. And so like the history of abortion goes back millennia. Like it's not something, and it wasn't criminal until the 20th century, the 20th century. So in the 1900s, that's when it became criminal. It wasn't criminal before that. It was just something that happened. It's just a part of life. So, abortion is literally a way to control your population, specifically half of your population who are women who don't want to, it's just a way. These laws are literally a way to control women and your population, specifically women of color, because they're the women who are disproportionately affected by it.
Okay. I can't disagree with that.
Just giving you a little bit of history.
Yeah.
I'm just saying, it is Native American History Month. Y'all need to know where this stuff comes from.
Okay, so we get into paragraph 34. And it says, perhaps it is not generally appreciated that the restrictive criminal abortion laws in effect in a majority of states today are relatively recent. Those laws generally proscribing, meaning banning, abortion or its attempt at any time during pregnancy, except when necessary to preserve the pregnant woman's life, are not of ancient or even common law origin. Instead, they derive from statutory changes effected for the most part in the latter half of the 19th century.
Literally what I just said. I didn't even know that's what that paragraph said. I'm smart.
Yes, you are. So
I didn't hear. I haven't read any of this. Like, this is Ron going through this, teaching me along with y'all. So the information that I give is information that I just happen that I know. I mean, being a woman, and this being very close to my heart, I know a lot about abortions. I know how they work. And there are multiple ways to have abortions. I've had to take a Plan B pill. Like, it's not a fun thing to do like they seem to think it is. It's not. It is horrifying to have to go through something like that.
Okay. I, as a man, can't say anything about that other than I agree with you.
So what are the ancient attitudes?
Okay. Paragraph 35, the ancient attitudes. And of course, they say these are not capable of precise determination. Because a lot of stuff has been lost over 3,000 years.
Right.
But at the time of the Persian Empire, abortionists were known and criminal abortions were severely punished. However, abortion was practiced in Greek times as well as in the Roman era, and it seems to have been resorted to without scruple, which means freely and
so it's a matter
no
of
repercussions.
So if I'm not mistaken, if I'm remembering correctly, which I'd have to do a little bit of research, which I don't have to do, I don't have enough time. But when they say criminal abortions, they're not talking about women, they're talking about people doing it in the back, like shady alleys, people who are forcing women to have abortions. That's what they're talking about when they're talking about criminal abortions back then, because it was a practice that, like I said, it just stated until the later half of the 19th century. Like it's when they say criminal abortions and why they punish them because of the way women were being treated.
Right. The Persian Empire, as in this paragraph, they call it the abortionists.
Abortive fashions.
Yeah.
Is that the word you're trying to say? That's what it looks like to me. Abortive fascients. That's
or fasciants.
Fasciants. Abortive fasciants.
Yeah. Which were practitioners of abortion.
Yes.
So the abortions that were severely punished back in the Persian Empire were the ones not done by the practitioners.
Yeah, like they're basically gynecologists who specialized in abortions.
Right. Now
it's like going to a dentist to do your abortion. That's not cool.
Right. There are some Greek and Roman philosophers that did not prescribe to the prevailing free abortion practices. However, they were in the minority. Greek and Roman law afforded little protection to the unborn. And here you go. If abortion was prosecuted in some places, it was based on the concept of a violation of the father's right to his offspring.
Who cares? An ancient religion did not bar abortion.
No, it did not.
I'm sorry. But you're not the one who has to carry that child for 9 months. It doesn't do anything to your body. You don't get to say so.
I just thought that you would have an opinion on the violation of the father's right to his offspring.
I think I think a father has an absolute right to know that they fathered a child, like they have every right to know that you got pregnant and that you've made this decision, but they do not have the right to make you change that decision or try to convince you to change that decision. They have every right to know, because yes, it takes two people to not tell someone that is it going to affect them? No. I get technically, but it will mentally, because they'll know, oh my God, I got somebody pregnant for being stupid, or whatever the situation is. They have the right to know about it, but they don't get to make that decision for you. Only the woman, only the person mothering that child has the right to decide if they want an abortion. And that's all I'm going to say about that.
Okay. Well, then we get into the whole Hippocratic Oath. And basically, the Hippocratic Oath is do no harm, to your patient. And in this case, they've actually quoted the oath in a few cases over the course of the Supreme Court. And they ask, why did not the authority of Hippocrates dissuade abortion practices in his time and that of Rome? And they go on. Most Greek thinkers, on the other hand, commended abortion, at least prior to viability. And they cite Plato in his Republic, Aristotle in his Politics, and Pythagoras. It was a matter of dogma. For the embryo was animate. For them, the embryo was animate from the moment of conception, and abortion meant destruction of the living thing. The abortion clause of the oath, therefore, echoes Pythagoras' doctrine, and no other stratum of Greek opinion were such views held. So, once again, that's in the minority. And it just goes on with some more stuff in 38 about the oath. And then in 39, the Supreme Court says, it seems to us a satisfactory and acceptable explanation of the Hippocratic Oath's apparent rigidity, and it enables us to understand in historical context long accepted and reverse statements of medical ethics.
Which means?
They understand why there is that school of thought that it is a living person and you shouldn't do any destruction, quote unquote, to the fetus. But they also know that it was a minority.
Mm-hmm. And that's the thing about
school of thought.
And that's the thing about it. It's still a minority. It seems like it's a majority, but it's actually a minority who feels this way about abortion. And the thing is, there's nothing wrong with that. If you don't believe in abortion, absolutely nothing wrong with that. But it's the fact that you are trying to criminally charge women who do believe in abortion and who feel the need to have an abortion for whatever their reason is, based off of your own truth. And that is not ever okay. When we live in a society, we have to think about the greater group of the society. And you're not going to like every law that's made. I certainly don't. But I also feel that the decisions that are made, it's more important to think about society as a whole and the group as a whole. What's going to make it best for us? And yeah, that's a very socialist ideology. But why wouldn't you think about people as a whole versus you and yourself? You're not the only person who lives in this world. That's all I'm going to say about that.
Okay.
I love that you pause because you're like, is she going to say any more or is she done? Like,
well, it, your opinions. I have nothing really to comment on them.
Because you have a penis.
I do.
So you don't really.
Yes, I do.
Like, you can have an opinion, but doesn't matter. You don't have what it takes. You're not the one who just had to have surgery on your baby box to clean shit out. Ugh. Anyway.
No, I'm not.
Anyway.
So that's the ancient that they went into, and then they get into English common law, paragraph 40. And if nobody realizes it, all of our jurisprudence in 49 states evolves from the English common law.
What's the state that it doesn't?
Louisiana.
Because because France.
It evolved from the Napoleonic codes.
Ah, okay. That's all right. That explains a lot about Louisiana. But yeah, that's so fun fact. If you are from America and you want to move to England and you're an attorney, you can actually take the bar. And if you pass it, practice law in England because we were a commonwealth. So almost every country in the world who was a commonwealth of England at one point, which is a lot, you can practice law because a lot of the laws in most of those countries are based off of English Commonwealth.
Yeah.
And what we mean by commonwealth, if you don't understand, is man,
all the countries that at one time were under the thumb of the English Empire.
Colonized. Thank you. That's the word I was looking for. All of the countries that were colonized by England are considered commonwealths, or were commonwealths of England. So that's where that comes from. So yes.
And some are still considered commonwealth.
I believe Canada still is, because they still hail to the Queen.
Yeah, they have the Queen on their money. If you still have the Queen on your money, you're still considered a Commonwealth country.
An active Commonwealth, yeah.
Yeah.
So
in common law, abortions performed before quickening. Now, what's quickening? Quickening is the first recognizable movement of the fetus in the uterus.
So that's when it starts moving. So that's
and that usually comes between
16th to the 18th week of pregnancy. Yeah, that's
right.
A little, and that's usually about the time when you learn whether or not it's gonna be a viable pregnancy anyway.
Right. It was not an offense, and the absence of that as a crime appears to have been developed from the earlier philosophical, theological, and religious and civil law of when life begins.
See, and that's one of the biggest problems when it comes to the abortion law, is the fact that theology creeps into it so much when it shouldn't. This should be based off of science, not off of religion, because there's more than one religion.
There is, but remember, with Henry VIII, religion and civil law in England became one and the same.
That's true. Fascinating book, by the way, if you like to read books and biographies. The Six Wives of Henry VIII by Allison Weir. Fantastic book. Fantastic book. Highly recommend. It's crazy. He was nuts. And you can't tell me that he didn't go crazy because of the syphilis. Like, I don't, because he was a good dude and a very, good leader. And then he got syphilis and his leg got hurt. And because they didn't know how to bathe and, take care of themselves. Because, fun fact, Native Americans are the ones who taught English people hygiene. the English were not hygienic until they colonized America because Native Americans taught them how to bathe.
If you washed your clothes, it ruined the cut of the fabric.
Yeah, and the nobles and stuff, the reason why I'm going to stop after this, I swear, but I find this stuff so fascinating. The nobles, the palaces and stuff, the reason why they didn't stay in one palace at a time is because they were so far from the bathrooms, they would just pop a squat right there and use the bathroom in the buildings. And so they would leave, they would do their tours around the different palaces so that they could have time to clean up the feces and the piss in the palaces.
Yeah.
It's gross. It's disgusting. It's disgusting.
Remember that the next time you're walking through the Palace of Versailles or the Tower of London.
Nasty. Anyway, so
you have this quickening theory.
Mm-hmm.
And what that developed into was this early loose consensus in early English law. And when they say early English law, it's like the 1500s.
So Tudor time.
Yeah. That they fixed the point of animation, which is when the soul became infused with the fetus, at 40 days for a male and 80 days for a female.
So men get their souls before women?
Apparently so, yes. And that view persisted until the 1800s.
You know that you do realize that all fetuses are female until like the middle of the second trimester, right? Like
when the sex organs develop.
Yeah, like
in their defense, this was the 1500s, and
I know
they didn't know shit.
I know, but I'm just saying, like, for those of you who are like, yeah, no, even you guys were women while you're in the womb until the sex organs started growing.
Yeah.
Okay.
Hi,
puppy.
So prior to this 40 to 80 day time period,
so wild.
The fetus was regarded as part of the mother, and its destruction, therefore, was not a homicide. But due to the continued uncertainty about the precise time when the soul entered the fetus, and due to the lack of any scientific basis for the 40 to 80 day view, and perhaps to St. Aquinas' definition of movement as one of the two first principles of life, they focused on quickening as the critical point. So in later common law, you're talking like 1600s to 1700s, the quickening was the deadline, basically, of having an abortion.
Yeah. Which 16 weeks, you're looking at just a little bit into the second trimester. Because 12 weeks is about 3 months. So, yeah, you're looking, I mean, you're at about the 4th to the 5th month at that point. So, honestly, that's not a bad spot, really. I mean, most people are going to know by then whether or not they want to keep the pregnancy. And when there are the really late term abortions, that's when there's something wrong with the baby or there's a life or death situation. After about 15 to 16 weeks, a mother's going to know whether or not they're going to be able to keep the baby. And I know that that's generalizing, but I mean, just based off of how the body changes and forms and stuff, you're showing by then, that actually sounds reasonable considering the time that you're in, being in the 1600s.
Well, and here we go in paragraph 41. They're talking about the abortion of a quick fetus, one that was moving. And there's three famous legal scholars that they talk about here. Bracton, in the early 13th century, thought it was a homicide.
Mm-hmm.
Later on, you've got Koch, not Coca-Cola, but his last name was Koch, who said that it was a great misprison, but not murder. And basically, misprison is a misdemeanor.
Okay.
And then you have Blackstone, who's probably the most famous, who considered it possibly manslaughter. And Blackstone is the one who codified all this common law into a set of statutes.
So he's the one who created what we have now, basically, or what we've built off of now.
Right. What the law in effect during the colonies was the Blackstone Statute.
Okay.
They still get quoted from time to time in federal decisions. Not often anymore, but sometimes.
And all of this, not a single one of these people are thinking about the mother in this. None of them are thinking about, none of this is talking about the person who's carrying the child. And that's what I think is a big problem is these lawmakers, our lawmakers including, talk a big game about this thing that's not even born yet. However, you don't think about the person that's carrying that child. You don't give a crap about that person, that actual person who's been alive for who knows, like back then, probably around 13 years because creepy. But like, where then does the mother actually get involved? Like, you're talking about this, the way they're talking about this is if it's in a vacuum, a child is created in a vacuum.
Well, they are going through the early history of abortion. And at that time, quite frankly, women were not seen as equal.
Oh, I know. We were property. We are still looked at as property. We're still seen as a commodity. That's the point I'm trying to make. Like, since the Tudor times and before, that I'm trying to draw that similarity.
And you're doing a good job. I just have to, put in my 2 cents about, how things were too.
Anyway, that's my point, is the fact that all of these laws, whether they're past or present, none of them think about the mother. None of them. And it's
will they until Roe comes around?
Anyway, continue on.
Okay. So the importance of all this is basically at the time of the Revolution and the writing of the Constitution, 1789, most American courts held that the abortion of an unquickened fetus was not criminal, and the abortion of a quickened fetus was a misdemeanor, not a murder.
Mm-hmm.
Okay. So then you get to the first English statutory law, and the first English criminal abortion statute came in 1803, and it made abortion of a quickened fetus a capital crime, but it provided lesser penalties for the felony of abortion before quickening, and thus preserve the quickening distinction. Now, this has no precedent on American law now, because it's after the revolution. We already became a country. They're throwing this in because they want to show the quickening distinction, because it's going to basically come up in their trimester guide.
Yeah, that's exactly what I was thinking. That's why, because, as I'm explaining this, I mean, that's you're sufficiently in your second trimester at 16 weeks.
Yeah.
I mean, it's a relatively small amount of time. I know it doesn't feel that way to a mother who's been pregnant or who is pregnant now. 9 months is a relatively small amount of time. And the fact that you don't normally know that you're pregnant until at least 6 weeks, maybe at least 6 weeks, because, first miss period. And that's a big decision to make in a relatively small amount of time. And by cutting the time shorter and shorter, does nothing but stress an already stressed individual out.
Right. Now, the next two paragraphs go into some more recent English law, 1929 Act, 1967 Act. And basically, they just go in to say that abortions are necessary when it's preserved the life of the mother. And that comes into play in their guidelines coming up. In paragraph 45, you get to the American law.
I think this is actually a good place to stop.
Oh, okay. I was just getting into it.
Well, we're at an hour, so
and we're on paragraph 45. We seem to be doing about 20 or so of the paragraphs. There's 120 paragraphs in this opinion. Well,
it's going to take a while to get through this, but there's a reason why we really want to go through and truly educate you on this with my interjection of opinions based off of the information that I know, and Ron going through teaching us, what these opinions, what these statements are for Roe v. Wade. Because there's a lot in it. Yes, it is mainly about abortion, but it's not just about abortion. There's a lot more involved, and we will eventually get to the rest of it. So I do hope that everybody's enjoying what we have done so far. I'm learning a lot on specifically this case.
Oh, yeah, I think there's a lot of historical law that people don't know about, because for example, everybody's like, well, the law should be when the Constitution was written. Well, when the Constitution was written, it wasn't a crime at all.
So I'd be okay going back to that. Ugh. Anyway, so thank you so much, everybody, for hanging out. Thank you for listening to Learning the Law. If you like this podcast and want to hear more, don't forget to subscribe, follow, and share in all your favorite places. And don't forget to follow us on Twitter at Learning the Law. You can find Ron at Necrokijo, that's Necrokijo, and me at Phoenix Nymphy. If you have any questions, please tweet, comment, or email us at twolazydogsmedia@gmail.com. This has been a Two Lazy Dogs production.
Bye, everyone.